Hello, everybody. Good morning. Good morning. I am attorney Deifilia Diaz, and we are on live. Good morning. So we are on live on in our channel that is normally in Spanish, but now I am doing an experiment, and we open a channel that is in English. So I'm attorney Deifilia Diaz. My firm is the Law Office of Valencia and Diaz. And on Fridays, we speak in English here in the lives. So today we are going to be speaking about the U visas. Normally, all Thursdays are U visa Thursdays in Spanish in my Spanish channel. However, my experiment, it is talking about U visas in English on Fridays because I am so sure that there is more people to be helped in the U visa world that do not only speak Spanish. So that's why on Friday we're gonna be speaking in English. I am so appreciative of the people that they are connecting in my Spanish speaking clients and subscribers. Thank you very much. So if you are seeing us in English, please subscribe to the channel. We are Valencia Diaz attorneys or attorneys at Valencia Diaz, so you can be notified when we are going live. Right now I cannot go live directly in that channel because I need to get to 100 subscribers and I'm like at 14, so we are so low. So please put the subscribe button in the English channel. How are you? So buenos dias. So we are in English. I'm going to be talking about the same news that I shared with you guys on Thursday. Sadly, I don't have a long time to spend with you because I have an interview for naturalizations today. So I'm so excited about my client that I'm going to be representing today for the naturalization because she was a minor that entered in 2014 to the country. So I have been with her, or she has been with me, whatever you want, however you want to see it. We have been together for all this time. So I help her with her petition of the special immigrant juvenile petition. And then she is getting her naturalization today. So it is an amazing process. And one day I will talk about more about the special immigrant juvenile petition for minors. It's only for minors, okay? So let's start with the news that we have this month for the U visa. And finally, we have some good news and some news at all from the U visa world because we have been just dry of good news and we have been just rehearsing the same information that we had from 2000 from the July or June to from the 21 to that we had a memorandum that implemented the bona fide determination. So we have been with no news from UCIS. So the news this month, it is that derivatives will be able to get the work permit even though the principal has not gotten the work permit in the review of the bona fide determination. So we have to start explaining a little bit more about before we fully understand what these big news are. So the bona fide determination was implemented June 2021. And we have a memorandum from UCIS, which is the agency that is deciding the U visa petitions, that is stated that they have realized that it's taking a long process for the U visas over the U visa applicants to be able to get a work permit. So they started a new review process that is called the bona fide determination, in which they are just reviewing the case very fast. And it's very fast and looking if the applicant it is including the bona fide, the very essential proofs or evidence that is required. So what they've been looking for in the principal applicant, it is the 918 petition, which is the U visa petition, the 918B certification, and it's not expired, an affidavit from the petitioner. And also, they are going to be looking if that petitioner is posing a threat to the community. So that means that they're going to be looking the results of the biometric, the fingerprinting. So if the principal passes that brief review, it has to be brief and fast. So they are not deep diving into the case at all. They are not looking into the immigration violations. They are not looking into inadmissibility grounds. They are just looking into, in this fast review process, just these 4 things that I mentioned. And if the principal passes, then that means that they will put it in a special bucket that is called deferred action. And then they will be said that case, the principal has a bona fide determination case. That seems to be approvable, but later on, they need to explore deeply. So when that it is approved, then they go, okay, the derivatives. The derivatives can be spouses, children, and parents, or siblings, depending if they qualify. Okay, so don't get so excited about all the family, depending if they qualify, but that's for another day. So it was before this big news that if the principal did not have a petition for their bona fide deferred action work permit petition, then they will not get started on the review of the derivative. And I explain further, okay? So for the principal, there is no need of a separate petition for the work permit. There is no need. However, since the things are getting so long, it is taking so long for USCIS to review the cases, then immigration started with a waiting list and then this new type of review. So when you are granted deferred action, you would need a separate work petition, a petition for a work permit. So, and if you don't have it, because that work petition it has to have a different category than the U visa. And if you are granted a U visa, one of the 10,000 U visas that they are awarded per year, then you don't need a work permit petition, but that is not happening right now. So normally the cases are not filed with the work petition C14 itself. My advice, and I have been doing this since 2017, my advice is always file the petition, the principal and the derivatives, always with a work petition authorization, C14 as well, and as well the category for the U visas, okay? So it was in the past that if immigration granted the bona fide determination and the principal did not have a petition upon which they can grant the work authorization permit, they will not go and review the derivatives. So they will be on hold until the principal will file the petition for the work authorization and grant that work authorization, and then they will go ahead and review the derivatives. Now, the big news is that even though that the principal do not have a separate petition for the work authorization, then they will go ahead and review the derivative to see if they qualify for the prima facie determination and get them into the deferred action status and then the work authorization. So for the derivatives, what immigration is looking for to being able to be granted deferred action, it is that they can be able to prove the qualified relationship. So if they are spouses of the principal, then the certificate of marriage. If they are children, well, the birth certificate, right? And if it's in any other language, it has to be translated and it has to be with an affidavit for the interpreter or the translator, right? So they're looking at that. They're looking that they have included the 918A, which is the petition for the derivatives. And also the derivatives have to pass the background check. So, because the derivatives are also required to go and get fingerprinting. Okay, so this is the big news. And again, I will repeat the summary of the big news on the U visa, which is that now USCIS, which is immigration in the visa world, it is now not waiting until the principal, it is awarded the work authorization permit when they are doing the bona fide determination, but it is if the principal it is awarded a grant or granted the bona fide determination, then they will pass into the derivative and start reviewing that package for the derivative to have their work permit and the deferred action status, which is amazing because, as again, normally, and some of the practice from some attorneys had been not to include a separate petition for the work authorization document, which is a 765 with a category C14, because the U visa principal doesn't require it, but it's a good practice always to have the C14. How do I know, I am Day, by the way. How do I know if my case has a C14 file, category C14 file? Well, it's super easy. Go with your attorney or check if you have your receipts. You should have your receipt for the case. So that means that your case has been filed. With the receipt, you will know when it is your date that the case has been filed, and that day is very important. So in that receipts, and you will have to look in the top right, then you will have to see if there is that receipt for specifically for the principal. It has to have your name and the 765 petition for work authorization, and then below that, but still in the upper right corner, then they will see category C14. Category C14, and for the derivatives is the same. You have to look if you have those receipts, and in that way you will be able to feel comfortable that you have a C14 work authorization petition filed along with your U visa petition. So what happened if my attorney did not file? It is not the end of the world. It can be corrected and amended, and the attorney can file it right now. So some attorneys, and I have been receiving some call from none of my clients, in their consultations, that the attorneys don't want to file a C14 right now, and they are waiting until they receive the determination for deferred action. And I said that is not the best practice, and is not in the best interest of the client. Why? Because if you wait for that decision and then you file the 765, then that means that that person, it has to wait at least between 6 and 12 months for the employment authorization document. So I am so sure that none of us want to wait that long in order for us to get the work authorization, because that's what we want. That's what we need to just keep improving our quality of life in this country. So it is the best practice and the best advice just to file it. So what about if they don't give me the deferred action? Nothing. It really doesn't nothing happens. It is just, it stays there in the limbo. And maybe if you get granted, like in the waiting list, you're placed in the waiting list, maybe you can get your work authorization document in that, when you are there. Now, you don't have to pay the C14 because that document, that petition doesn't have a cost. So when UCIS came with a memorandum in June 2021, it came with a memorandum that stated that they were going to be implementing a bona fide determination review, the quick review. Then they said, well, and that when that principal or derivative gets to file the 765, that is not going to be required a 410 fee. So you are not losing anything. So it is best for you guys to make sure if you have a U visa pending, make sure that you have a C14. And I am also being told that because they hear it and they have heard it from us, they have pushed their attorneys, their representatives, to file the C14, and in that way they were able to get their work permit sooner. So that means that I am going to get my work permit immediately after I file the U visa. No, it's not the case. It's not the case. Right now, the processing times, I know that it is crazy about the processing times, to know about the processing times. The processing times for the U visa right now, UCIS is reviewing the cases that they were filed in 2018. 2018, by the end of 2018. So I'm also seeing the review of some cases that they were filed in the summer of 2018. So don't get crazy and just pulling your hair thinking that if you file in February 2018, I'm just, something happened to me and I've forgotten. That's not the case. Just wait, okay? Just wait. But if you filed your case in October 1st, 2017, or before that day, then immigration is saying now you can send us an inquiry. And the inquiry, it is nothing less than an email. It has to be an email. So the U visas are very strange and rare. So U visas, T visas, and VAWAs, they're treated very differently from any other petition. So that inquiry has to be in a form of an email coming from your attorney, because if you send the email, they're not going to respond to you. If you wanted to get an inquiry for your own case, it has to be in writing and it has to have certain requirements. So it would be easy if your attorney will send that inquiry directly to USCIS, and your attorney should know the email. It is not any email, it is called a hotline. So in that inquiry, if you filed your case 2017, October 1st, 2017 or before, then you could see what's going on. Now, the other question that I get, it is, do you think that I'm gonna get my U visa, one of the 10,000 awarded per fiscal year? Do you think that I'm gonna get it? Well, we don't know for sure. There is no way to actually know for sure 100%. But the things that I see on my guesstimate, it is that if you filed your U visa case in the second semester of 2016, perhaps you will see in the next fiscal year that starts October 1st this year, then you could probably see that you are being granted your U visa, one of the 10,000 visas awarded per year. Okay, so I'm gonna see a couple comments. So that's the other thing. When I go live, I can interact with you, but my interaction will not, it is not a legal advice. So you will still have to go and get in contact with an attorney. If you want to call us to Valencia and Diaz, that's fine. We'll welcome you into the Valencia and Diaz family. And our telephone number, it is 513-618-2005. Miguel, buenos días. Pedro Lomas, thank you very much. From Denver, Miguel. I just said the processing times, so today is in English. I'm so sorry for the people that they are watching and they cannot understand. However, I know that YouTube has a feature where you can put subtitles and then they can translate it for us. Okay, so okay, this is Nancy. This is in English. Can my son extend an invitation to his grandmother to come over and visit him? If so, what is the waiting time? So I am assuming that she is undocumented. She doesn't have a status in the country. I'm assuming that the son is a U.S. citizen and the grandmother wants to come and visit. Yeah, the grandmother can apply for the tourist visa. The son can extend that invitation letter, but that is not gonna do anything if the officer at the consulate will deem that the grandmother has a potential risk and high risk to stay in the country undocumented or overstay their visa. So what it is you have to be more concerned and focusing on the grandmother. I'm assuming your mom, Nancy, the grandmother, be showing that they have ties, strong ties to the country, to their country, not to this country, the United States, to their country. So that can be shown in a way of retirement, if they have retirement properties, bank accounts. I am assuming that the grandmother doesn't have an employment, and if so, also showing that they have more family to be cared for in their home country and they're not going to be staying here in the United States. What year going the memorandum of the U visa? So what I'm talking right now, it is an update. It's an update. It's not a memorandum. It's an update to the policy manual, USCIS policy manual. The memorandum that it was that changed how the things are going. It was issued in June 2021. Okay. It says, Miguel, your internet is not working really good. I don't see any other complaint. Maybe it's yours, Miguel. Juanita, if I brought my kid when she was 6 months, and she doesn't have DACA, and she gets married with a U.S. citizen, she has to go to Mexico during her process. It all depends, probably and most likely, but you need a consultation. I cannot give you legal advice. I need a little bit more. Juanita, call the office, or perhaps it will be better if your daughter calls the office, because I will have more questions for your daughter. Attorney, I have a U visa. Oigan, ya, I am just getting a little bit older and I need my glasses. Okay, much better. I have a U visa and I found a decent job, but one time I applied to Chase Bank and they said, even though you have a U visa, we will still need to sponsor you a new visa, which makes no sense. Well, maybe they need an education. I see what you're saying. So she's saying that even though that she had a work permit and a U visa, that Chase Bank said, oh, you still need a sponsor for a new type of visa. That can probably be if they, it has to, I need more information. I don't know if they're discriminating against you because you have a U visa and they want something else, but you are allowed to work if you have a U visa. So it doesn't really make sense. Maybe your attorney can give them a call and educate them as saying, well, she's able to work and you don't need to get a new visa for her. So I tried to explain the same situation. I tried to explain that my EAD, which is employment authorization document, is valid to work. And she said, no, I am so sure many companies never heard of U visa, but I did. She probably break the law by denying me employment, even though probably that's right, because the I-9, which is the form that is being used to verify whether or not you can actually work, that says that the different type of documents explains the different type of documents that you can show to be able to show to the employer that you are able to work. So probably, yeah, you are I didn't need a sponsorship. No, you didn't need a sponsorship to work. So you can go back. You can go back and say, are you discriminating me because I have a U visa? So if so, I will file a complaint because I am able to work. Or is there any other reason why you're not giving me employment? Okay. You say, I'm living in the border or Mexico. I don't know. Okay, thank you. Thank you. Okay, Juanita, muchas gracias. I'm going to send them a letter. Perfect. And let me know what they say. Because one of the things that I hate to see, it is that immigrants, they get abused or they get violated their immigration rights or their rights at all just because they are immigrants and just because they look different, they talk different. I have an accent in English and we talk different, we dress different, we behave different, and just because we are different, that doesn't mean that we are less of a human. So we have to learn what is our rights, and this is the purpose of these videos. That's why I opened the channel in English, because I'm so sure that there is one person that we can help in English that doesn't speak in Spanish, that which is my mother language, and needs to learn and needs to be empowered to say no more to me. No more. Okay, I'm gonna do something about it because my intuition is telling me that this is wrong. And go with your intuition, believe your intuition. Just not because you're an immigrant in this country means that everything that you feel or believe, it is wrong. Okay, so think about that. And with that, I'm gonna say bye to you for now and remind you what is our mission at Valencia Diaz, which is empower, inform, and educate minorities, which includes women, kids, minors, which are children, immigrants in these countries, so they can be fulfilled with their family in the United States. And we develop and we fulfill this mission in this country by helping immigrants. So please subscribe if you are listening to me in English. Please subscribe. Hit the subscribe button and the little bell that is appearing there, so it can tell you that when we are going live and you can interact with me. However, the interaction does not substitute legal advice. You will still have to call an attorney. Okay, have a wonderful day and have a wonderful weekend. See you later. Ciao, ciao.